Real property isn't just about owning land. It's about how long, and under what conditions we own or even possess the land. And that's what we're going to discuss in this video. Let's start with estates. What is an estate? Well, the Black's Law Dictionary defines it as the amount, degree, nature, and quality of a person's interest in land and other property, but in this video we're talking about inland, real estate. This can range from absolutely owning it and controlling it to just possessing it. Ordinarily, when we think of property, we think of only one kind of way that we have it, and that's absolute ownership. The owner of a car has the right to drive it where and when she wants, rebuild it, repaint it, sell it, or even scrap it. The notion that the owner might lose her property when a particular event happens is foreign to our concept when it's related to personal property. But it's not the case with real property. You would think it quite odd if you were sold a used car subject to the condition that you're not painted a different color, and that if you did, you would automatically be stripped of ownership. But land and real estate can be sold that way. So real property operates under fundamentally different rules than personal property, which allows for conditional ownership and other complex interest structures. And we're going to talk about some of those in this video and the next. Land and other real property can be divided into many categories of interest. Now, don't confuse interest in real property with forms of ownership. Forms of ownership deals with the particular person or persons who own it. Interest is what a person has in the property. The law distinguishes estates among two main axes. The first is freehold estates versus leaseholds, and present versus future interests. Freehold estate is an interest in land that has an uncertain duration, like outright ownership, right? You have no idea how long you're going to own it. Nobody knows how long you're going to own it. You can own it forever. When you die, it'll pass to your heirs or whoever you leave it to. A life estate, which we'll talk about here in a little bit, is also a freehold estate. Then we have leasehold estates, and that's an interest in land that has a termination date that is usually known. So for example, you have a 1-year lease in that building or in that house. That would be an example of a leasehold estate. In this section, we will be discussing present and future freehold estates and interests. Present estates or freeholds. A fee simple absolute, also known as fee simple or in fee. We say somebody owns it in fee simple, we say it owns in fee. This is the strongest form of ownership interest. This is what we think of when we say a person owns the land. So I own my home and my land, it's in my name, and I have unfretted interest. As one court said, the grant of a fee in land conveys to the grantee complete ownership immediately and forever, with the right of possession from boundary to boundary and from the center of the earth to the sky, together with all lawful uses thereof. This fee simple absolute, this results in complete control over that real estate. Not every transfer of real property creates a fee simple absolute, though. Some transfers may limit the estate. One of those limits is a fee simple defeasible, which is any transfer of land specifying that the ownership will terminate upon a particular happening. So for example, Dr. Walters conveys a tract of land to, quote, to Miss Mary Smith for the purposes of operating her hospital and for no other purpose. Conveyance to be good as long as hospital remains on the property, end quote. This grant of land will remain the property of Mary Smith and her heirs so long as she and they maintain a hospital. When they stop doing so, the land automatically reverts back to Dr. Walters or his heirs if Dr. Walters has passed, without having to do anything else, by the way, to regain title. So this is conditional. Has to use a hospital. It can last for ever, but once, only if they're using a hospital, but once stop using the land for the hospital, it's going to be reverted back to the transferor. Life estates is another type of estate. It's an estate measured by the life of a particular person. These are usually created privately by parties themselves. It's common with estate planning. It prevents the need to go to probate court for a deed from the court after someone passes. So we see it happening in that circumstances. The simplest form is the conveyance by the following words. Quote, to Rebecca Fox for life. That's it, somewhere in the deed. Rebecca becomes a life tenant. As such, she is the owner of the property and may occupy it for life or lease it or even sell it, but the new tenant or buyer can acquire only as much as Rebecca has to give, which is ownership for her life. So all she can sell is a life estate in the land, not a fee simple absolute. If Rebecca sells the house and dies a month later, the buyer's interest would terminate. A life estate may be based on the life of someone other than the life tenant. So, to Rebecca Fox for life of Robert Jones. Robert Jones dies, Rebecca's life tenancy terminates or expires. Let's talk about future estates. We were talking about present estates. In the present, they had possession or interest in the real property in the present. Future estates, people can have future interest in real property. Technically, the person owns the future interest now, but is not available to be used or enjoyed now. These future interests can be bought or sold or given, just like land held in fee simple absolute. We have two major categories that fall under future estates. We have reversions and remainder. A reversion arises whenever the estate transferred has a duration less than that originally owned by the transferor. For example, the life estate, right? Upon the death of the life tenant, the property reverts back to the grantor. So if the grantor has predeceased the life of the tenant, it reverts to the grantor's heirs. Reversions, reverting back. This would also occur with the example of Mary Smith. When she stops using the land for the hospital, reverts back to the grantor. Another future estate is a remainder. Here, the transferor need not keep the reversionary interest or the reversion interest. Our transferor can give the interest to somebody else, the remainder interest. That person we call the remainder men. The remainder of the property is then transferred to that named individual. So for example, to Rebecca Fox for life, then to Steve Johnson. Rebecca has a life estate. Stephen has a vested remainder interest. When Rebecca Fox dies, the remainder goes to Stephen, or heirs if Stephen had predeceased Rebecca. And it would automatically be fee simple absolute because there's no restrictions or conditions on that. It's Stephen or the heirs will receive that property in fee simple absolute automatically. Some remainder interests are contingent. We call this contingent remainder interest. There must be a happening of a certain event. So for example, to my mother for her life, then to my sister, Sherry, if she marries Harold Jones before my mother dies. So lots happening there. Sherry will become the owner of the property in fee simple only if she marries Harold Jones while her mother's alive. If her mother dies beforehand, she doesn't get the property, and the property will revert back to the grantor or the grantor's heirs. As you can see, these reversions and remainders can become very complex. Easements. This is not a possessory interest. It's another type of interest. You just get to use the land. You don't possess it. An easement generally is an interest in land created by agreement that permits one person to make use of another's estate. This interest can be extended to what's called a profit, which allows the taking of something from somebody's land. Common law distinguished between easements and profits, but today profits are treated just like an easement. A license, which is permission, but it's not a creation of an interest in land or use. This can be revoked at any time by the owner. An easement is an estate. A license is personal to the grantee, and it's not what we say assignable, which means the grantee can't let somebody else use it with their permission. So an example of a license would be you've given your friend permission to hunt on your property that you own in northern New York. That's a license. You can take it away at any time, and your friend cannot let other people go on. Oh, sure, I got the right to use this land. You can go use it. Also, an example of a license is you buy a ticket to go to the movies. You bought the ticket ahead of time, and then you come back to go to the movies, and you're not wearing shoes and a shirt, so they don't allow you in, and you're like, but I got a ticket. It can be revoked at any time. That's a form of a license as well. Easements is a little different. They need to be in writing, and there's a lot more to them, and that's what we're going to talk about next. How do we create an easement? Well, they can be created expressly, or they can be implied. Expressly is the most common one. This occurs where the owner expressly grants another party an easement across their property, or an easement by grant is another way we say it. An example of this is a right-of-way, allowing someone to cross another's property to reach a road or to reach another property. They don't possess it, they just get to use it. Easement by reservation. This occurs when an owner sells land that he or she owns to another party, but preserves an easement on the sold land. So for example, I sell a piece of property that has a spring on it, and I retain access to the spring so I can get water. I just created an easement by reservation. Implied easements. These are easements created by the actions of the parties or the circumstances. The first one, easement by necessity. A party who owns a landlocked property, basically they have no way in and out to reach the property, they may be granted, or they will be granted, an implied easement to cross a surrounding piece of property to reach the road. And when I say they will be granted, even if you have a difficult property owner that won't let somebody cross, a court order will create one. And you'll get an easement, because otherwise the property is going to be deemed useless, and courts don't like that. So parties may agree, but in the end, if they don't, the person who's landlocked will probably be forced to go to court to get an easement, or to request an easement by necessity. Easements by prescription is another implied easement. It's an easement that is created by what we call adverse possession. You can also take ownership of property by adverse possession as well. I'm going to talk about it here with regards to easements. I will talk about it again in the video regarding taking ownership. But remember, easements is a use to use property. A person has been using a road that crosses another's property and meets the requirements for the statutory law for adverse possession. One can acquire use for it permanently. So they're just using it. Maybe nobody's paying attention and they've used it for, well, New York it's 10 years, other states it's a lot more, but they've used this property or this road for 10 years, and then all of a sudden a new owner comes in and says, hey, stop using the road. You can go to court and seek a easement by adverse possession as long as you meet the requirements. The requirements are you're using it adverse to the owner, must have some interference with the owner's rights, meaning you're using their property. Under a claim of right, the user must act as if they have been using that as though they have a legal right to use it. They don't have to be sneaky about it or appears to be trespassing on it, that they feel like they have a legal right to use it. They have to be doing it open, so we can see it, it's not secret, and exclusive. So continuously using it. If they stop using it for a year and then go back to using it, the clock restarts. And if they've been doing this for a period of 10 years, there's a good chance that a court would award an easement by adverse possession. Easements are an interest of land, and because they are an interest in land, they must be in writing to satisfy the state's statute of frauds. It's usually found in a deed, especially those that are expressly granted. Those easements that are created other than being expressed, a court order is going to be required to get the documentation.